because it kind of depends on whether this is written into an EHCP. I'm going to assume for starters this is written into an EHCP. We see this all the time, don't we, Sarah? So-and-so intervention advised by the OT will be delivered for 6 weeks, and then the school will decide whether it needs to carry on. That is illegal. All right.
To review. That's another
one.
Yeah,
or is subject to review. That's not legal. Because as an EHCP must specify and quantify the provision, and the provision is not legally allowed to be removed outside of the annual review process, because a school can just take it away at 6 weeks. There is no legal right to challenge that. If the local authority take it away at annual review and you disagree, you can appeal to tribunal. So there is a legal route to challenge it. So an EHCP is not legally allowed to time limit provision. The way that provision is reviewed legally is through the annual review. If the school feel the OT, so I'm talking about an OT intervention, if the OT intervention needs to happen every week, the EHCP must say it needs to happen every week. If the school feel the child no longer needs it anymore, then what the school have to do is call an early annual review. They bring their evidence to the early annual review, and they must provide their evidence 2 weeks before the annual review. We've got a webinar on annual reviews if you need more information on how to do this, but the school must send you their evidence 2 weeks before the annual review. You turn up at the meeting, you evidence what you feel, what the OT feels, anything else that might be useful. The local authority make the decision. If they make the decision to remove the provision based on the school's say-so, which they may well do because it's going to save them money, you then appeal. A judge will then look at it and make a decision. But a judge, if it was an OT provision, for an example, a judge would go with what an OT was saying above what a school was saying, because an OT is far more qualified to know what OT provision should be provided than a school. I've been a teacher for donkey's years. I have never, in all of my teacher training, I never met an OT. I've never had any training from an OT. I've picked stuff up along the way from EHCPs, but most of my training has actually come as a mum from my own child's OT.
And to just, if they want to kind of like go back and use a bit more something with actual, meat and bones behind it, Children and Families Act 2014, section 36(3) specifies that the local authority must determine whether special educational provision may be necessary, reinforcing that the local authority must determine rather than leaving matters for future assessment. So that it has to be, it's not just left it dangling in the air. The provision that is put into an EHCP can only be removed at an annual review, because it gives you the right of appeal, like Anna said.
Well, unless the parent can find evidence from an EP, I'm guessing in this case, assuming it's a general education intervention, it's ball skills, so it would be OT related. So unless the parent can find, has an OT assessment done and the OT states otherwise, then they're going to have to just go to the transition review and argue their own case.
But it's circuit, so that would need to be specified in your section F, and need to say, rather than being in blocks of. Quite often see provision, therapeutic intervention is put into an EHCP, and it's provided in blocks of X amount of weeks or X amount of terms, or it will say for X amount of time. When I do a draft check, I always put minimum of, because it's not going to be for that length of time. Saying something is going to happen for up to 10 minutes a day, well, if that's up to, that could be a minute. Needs to be a minimum of that time. It's very much dependent upon how this is written, and that's what we find a huge amount of times we will have, and I've just seen it, this has come from tribunal. Just because you've been to tribunal with an EHCP does not necessarily mean that the provision in your section F is watertight, because if you didn't go to tribunal having had your EHCP checked thoroughly, and having all those words taken out and changed, and going back to your professionals and saying to them, really sorry, but this is not worded correctly. This is too vague. This leaves this open for change. you must make sure, even if you've gone to appeal, that your section F is absolutely as good as you possibly can. And that means having it checked for legality and making sure that your reports are very high quality and making sure that all the information from your professional reports is in B and F. That's really, really important.
Yeah, and professional advice is a bit of it. I always describe it as a bit like top trumps. If the only advice on the table is from a teacher or a Senko or a head teacher, it's professional advice. It's likely to win. If there is professional advice on the table from the Senko, for example, and from an educational psychologist, and it's different, their advice differs, the EP advice will win because an EP is far more professionally qualified than a Senko. If it's about OT provision, sensory circuits, or ball skills or BOT provision, an OT, their advice would out-trump a school's advice any day. So you're going to need to think, if the school are really evidencing this, you're going to need to think about how you're going to get your evidence that they're wrong. Parents know their children, but the fact that I believe you is irrelevant. The fact that you're right is irrelevant. It's not professional evidence. You need it coming from an OT if it's about sensory circuits or ball skills.